Okay, it's a new day and a new voice. Here's hoping it holds out so we can do part 2 of going through the decision of Dobbs v. Jackson Women's Health Organization. This is the one that overturned Roe v. Wade and Casey v. Planned Parenthood. So, in the previous one, I went over Alito's very long-winded decision. So, I thought I'd just bullet point it before we get on to the concurrences. So, basically, Alito said it's all overturned because in order for there to be a liberty right under the Fourth Amendment's Due Process Clause, life, liberty, and property, there would need to be a tradition of abortion rights in America, and as of 1973, there just wasn't. And in fact, most abortions were illegal in all 50 states. The term viability is ill-defined and unworkable. There's no basis, precedent, or guidance for the undue burden standard. Stare decisis isn't there to protect bad precedents such as Brown or Plessy. Stare decisis is the lawyer Latin, meaning you go with the precedent, but you don't always want to. You know, Plessy v. Ferguson, you don't want that to be the law of the land forever. So, Roe and Casey claimed, especially Casey, wanted to bring about a national settlement on abortion, and it did exactly the opposite of what it intended. In contract law, they would call that frustration of purpose. I don't know if that's a concept that really applies here, but the effect of it is the same. They didn't have the intent that, they were wanting the ruling to have. So, and even many abortion rights supporters have criticized Roe and Casey, including, people like Ruth Bader Ginsburg. And I linked to one in the previous video. You might want to go and check that out. And it is time to heed the Constitution and return the issue of abortion to the people's elected representatives. So, it was a decision that didn't give either side what they wanted. The pro-choicers want abortion to be an established constitutional right, and the Supreme Court found that it wasn't. Pro-lifers wanted the fetus to be declared a person under the 14th Amendment. They didn't do that either. So, this is just starting over from scratch, send it back down, have the state legislatures figure it out, and then we can, go over it in the lower court cases and get it right this time. So that was what Alito was saying. So let's go into Thomas's concurrence, and this begins on page 117 of the PDF file, but again, the page numbers start over, so it's actually page 1. Yeah. That's really, really nice, isn't it? So, okay, bottom of page 1, going into page 2. I write separately to emphasize a second, more fundamental reason why there is no abortion guarantee lurking in the Due Process Clause. Considerable historical evidence indicates that due process of law merely required executive and judicial actors to comply with legislative enactments and the common law when depriving a person of life, liberty, or property. Other sources, by contrast, suggest that due process of law prohibited legislators from authorizing the deprivation of a person's life, liberty, or property without providing him the customary procedures to which freemen were entitled by the old law of England. Either way, the Due Process Clause at most guarantees process. It does not, as the court's substantive due process cases suppose, forbid the government to infringe certain fundamental liberty interests at all, no matter what processes are provided. So if it's a fundamental right, like the right to freedom of speech, right to keep and bear arms, there is no due process because there's no process that can infringe on it. It only has to deal with, other liberties, like your right to property. They can only seize your property if they get a proper warrant, things like that. So, and what we see over here on pages 3 and 4 is he says, in future cases, we should reconsider all of this court's substantive due process precedent. So he doesn't like substantive due process. And I'm linking below to a legal dictionary definition of it. You can check it out for yourself. Basically, it's about how do you apply the rights in the Constitution, such as the right to free speech, right to vote, right to keep and bear arms, and so on. How do you apply that to the states with the 14th Amendment? And it also means applying any rights that are rooted in U.S. history and tradition. And their recent Second Amendment case is a good example of that. I covered that in the Bogosity podcast on 26 June of this year, 2022. It was just a week or two ago. So go and check that out. Then this was a big part of that decision about the history and tradition of recognizing gun rights and people wanting to keep and bear arms for their own defense or for various other reasons. So, all right, continuing on. After overruling these demonstrably erroneous decisions, the question would remain whether other constitutional provisions guarantee the myriad rights that our substantive due process cases have generated. For example, we could consider whether any of the rights announced in this court's substantive due process cases are privileges or immunities of citizens under the United States protected by the 14th Amendment. To answer that question, we would need to decide important antecedent questions, including whether the Privileges or Immunities Clause protects any rights that are not enumerated in the Constitution, and if so, how to identify those rights. That said, even if the clause does protect unenumerated rights, the court conclusively demonstrates that abortion is not one of them under any plausible interpretive approach. And going over to page 7. Because the court properly applies our substantive due process precedents to reject the fabrication of a constitutional right to abortion, and because this case does not present the opportunity to reject substantive due process entirely, I join the court's opinion. But in future cases, we should follow the text of the Constitution, which sets forth certain substantive rights that cannot be taken away, and adds, beyond that, a right to due process when life, liberty, or property is to be taken away. Substantive due process conflicts with that textual command and has harmed our country in many ways. Accordingly, we should eliminate it from our jurisprudence at the earliest opportunity. And so here's where we see a lot of the claims people are making about Thomas. It's just outright lies. They were saying, oh, he's overturning all privacy everywhere. No, that is not what he's doing. First of all, he's talking about future cases, what he'd like to see considered. And second, he wasn't really saying that he would deny these under the 9th Amendment or the Privileges and Immunities Clause. He was just saying that it couldn't be done under the liberty part of the Due Process Clause. So, that's Thomas's big point. And these concurrences aren't that long because since they're concurring, most of it is basically going, hey, what he said. So, Kavanaugh is the same way. His concurrence starts on page 124. And so I'm starting here on page 2, which is 125. So this is pages 2 through 3. Many Americans of good faith would prioritize the interests of the pregnant woman. Many other Americans of good faith instead would prioritize the interests in protecting fetal life, at least unless, for example, an abortion is necessary to save the life of the mother. Of course, many Americans are conflicted or have nuanced views that may vary depending on the particular time in pregnancy or the particular circumstances of pregnancy. The issue before this court, however, is not the policy or morality of abortion. The issue before this court is what the Constitution says about abortion. The Constitution does not take sides on the issue of abortion. The text of the Constitution does not refer to or encompass abortion. To be sure, this court has held that the Constitution protects unenumerated rights that are deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. But a right to abortion is not deeply rooted in American history and tradition, as the court today thoroughly explains. On the question of abortion, the Constitution is therefore neither pro-life nor pro-choice. The Constitution is neutral and leaves the issue for the people and their elected representatives to resolve through the democratic process in the states or Congress, like the numerous other difficult questions of American social and economic policy that the Constitution does not address. So again, neither side is getting what they want. Alright, in page 10, some of the other abortion-related legal questions raised by today's decision are not especially difficult as a constitutional matter. For example, may a state bar a resident of that state from traveling to another state to obtain an abortion? In my view, the answer is no, based on the constitutional right to interstate travel. May a state retroactively impose liability or punishment for an abortion that occurred before today's decision takes effect? In my view, the answer is no, based on the Due Process Clause or the Ex Post Facto Clause. And this is something else that Congress would absolutely have the constitutional power to legislate. The right to interstate travel has been recognized since Gibbons v. Ogden, and Congress could absolutely pass a law saying that no state should prevent travel to another state for the purposes of obtaining an abortion. So, when the Democrats are always wanting, there's nothing we can do. Yeah, there are things you can do. There are things Congress can do. And be completely consistent with their proper enumerated powers in the Constitution and with this decision. Okay, so we also have Roberts doing a concurrence, but he's only concurring with the judgment, not the reasoning behind it. So this is page 136 of the PDF file. Again, we're restarting the page numbering, and I'm looking at pages 1 through 2. I would take a more measured course. I agree with the court that the viability line established by Roe and Casey should be discarded under a straightforward stare decisis analysis. That line never made any sense. No, it didn't. It made no sense at all. Our abortion precedents describe the right at issue as a woman's right to choose to terminate her pregnancy. That right should therefore extend far enough to ensure a reasonable opportunity to choose, but need not extend any further, certainly not all the way to viability. And going over to page 11, that is page 146 of the PDF file, the court's decision to overrule Roe and Casey is a serious jolt to the legal system, regardless of how you view those cases. A narrower decision rejecting the misguided viability line would be markedly less unsettling, and nothing more is needed to decide this case. Our cases say that the effect of overruling a precedent on reliance interests is a factor to consider in deciding whether to take such a step, and respondents argue that generations of women have relied on the right to an abortion in organizing their relationships and planning their futures. The court questions whether these concerns are pertinent under our precedents, but the issue would not even arise with the decision rejecting only the viability line. It cannot be reasonably argued that women have shaped their lives in part on the assumption that they would be able to abort up to viability as opposed to 15 weeks. And page 12, both the court's opinion and the dissent display a relentless freedom from doubt on the legal issue that I cannot share. I am not sure, for example, that a ban on terminating a pregnancy from the moment of conception must be treated the same under the Constitution as a ban under 15 weeks. A thoughtful member of this court once counseled that the difficulty of a question admonishes us to observe the wise limitations on our function and to confine ourselves to deciding only what is necessary to the disposition of the immediate case. I would decide the question we granted review to answer whether the previously recognized abortion right bars all abortion restrictions prior to viability, such that a ban on abortions after 15 weeks of pregnancy is necessarily unlawful. The answer to that question is no, and there is no need to go further to decide this case. I mean, it sounds a bit more reasonable. You don't want to do any more than is necessary to decide the immediate case, but Alito had a response to this, and this is going back to page 76 of his decision. That's 84 of the PDF, so move back to that if you're following along. If we held only that Mississippi's 15-week rule is unconstitutional, we would soon be called upon to pass on the constitutionality of a panoply of laws with shorter deadlines or no deadline at all. The measured course charted by the concurrence would be fraught with turmoil until the court answered the question that the concurrence seeks to defer. Even if the court ultimately adopted the new rule suggested by the concurrence, we would be faced with the difficult problem of spelling out what it means. All right, and a bit lower. And if this new right aims to give women a reasonable opportunity to get an abortion, it would be necessary to decide whether factors other than promptness in deciding might have a bearing on whether such an opportunity was available. In sum, the concurrence's quest for a middle way would only put off the day when we would be forced to confront the question we now decide. The turmoil wrought by Roe and Casey would be prolonged. So, yeah, if you're not going to go ahead and do it now, what does that mean? You do it, okay, well, now we're doing 14 weeks, now we're doing 12 weeks, now we're doing 9, now we're doing 8, now we're doing this, now we're doing that, now we're doing this other thing. And when do you actually figure out the fundamental issue? So, just go ahead and deal with it. Casey and Roe are just too unworkable, so the decision is go back and start over. All right, the dissent starts on page 148, and this is from the 3 liberal justices. I'm going to start on page 3, which is page 150 of the PDF file. And I think you'll notice that with this dissent, there is a very obvious difference in character, shall we say, but we'll get there. Above all others, women lacking financial resources will suffer from today's decision. In any event, interstate restrictions will also soon be in the offing. After this decision, some states may block women from traveling out of state to obtain abortions, or even from receiving abortion medications from out of state. Some may criminalize efforts, including the provision of information or funding, to help women gain access to other states' abortion services. Most threatening of all, no language in today's decision stops the federal government from prohibiting abortions nationwide, once again from the moment of conception and without exceptions for rape or incest. If that happens, the views of an individual state's citizens will not matter. The challenge for a woman will be to finance a trip not to New York or California, but to Toronto. Oh, we just saw that's a lie, didn't we? No, the ruling specifically says otherwise. That this is only about the states, and no, states can't do that. And I really hate it when they do that, and these 3 are especially prone. Ginsburg did this too with a lot of her dissents. Here's the thing. If it says so in the ruling, it's part of the ruling. That's what the ruling is. So the ruling is what the opinion says it is. And if the opinion says that it doesn't stop travel to another state for purposes of obtaining abortion, then it doesn't stop it. You know, just like if the opinion says it doesn't apply to marriage or contraception, then it doesn't apply to marriage or contraception. And especially when they're explaining in detail how these are fundamental differences in kind, and not really, leaving any room for doubt. But that's exactly what they go on to lie about in pages 4 and 5. And no one should be confident that this majority is done with its work. The right Roe and Casey recognize does not stand alone. To the contrary, the court has linked it for decades to other settled freedoms involving bodily integrity, familial relationships, and procreation. Most obviously, the right to terminate a pregnancy arose straight out of the right to purchase and use contraception. In turn, those rights led, more recently, to rights of same-sex intimacy and marriage. They are all part of the same constitutional fabric protecting autonomous decision-making over the most personal of life decisions. The ruling explains at much length, thanks so much for being wordy, Alito, but why these are fundamentally different. Because with those other cases, contraception and stuff like that, you don't have the interests of the unborn person that you're trying to balance it out with. And any future court will have to take note of those differences and of exactly what was said in the opinion. And this dissent it's hilarious because then they go on to cry out for the importance of stare decisis. Since when have you three ever considered stare decisis to be important? You throw it to the four winds anytime you friggin' feel like it. Only now, when you need a reason for it, do you bring it up. When the ruling goes to enormous lengths to cover why it doesn't apply here, and you don't respond to any of that. And I mean, to be fair, it may be the case that Alito as well started off with this conclusion. He wanted to overturn Roe versus Wade. He needed to get around stare decisis, so he needed to find reasons. But even if that's the case, Alito found good reasons that he spent many pages explaining. These people, they're basically just going, is not. I mean, it's like, how are these people judges? Look over here, page 56 of their dissent, page 203 in the PDF. They mention, quote, the law of stare decisis. Stare decisis isn't a law. It's a legal doctrine. How do you even graduate law school without knowing the difference? And remember, I'm pro-choice here. You're not doing our side any favors. The only people who consider this dissent to be any good are people who are just cheerleaders for the left. But there are so many of us who are pro-choice who have felt that there are profound problems with Roe versus Wade. And no, this decision isn't really what, we want, but I can kind of see the point for, okay, let's just scrap it all and start over. I can kind of see that. You're not giving any reasons not to. Yeah, I mean, and also, I feel I have to mention, if anything, these guys are even wordier than Alito. I don't know. You want a good dissent? I got a good dissent for you. The decisions that I make with the doctor, with my doctor, between me and him, are none of the state's business. Gee, I wonder why you guys didn't want to make that argument. Nope, that's the last thing they want. But oh God, it's just embarrassing when your dissent relies on points that the decision itself completely eviscerated. I mean, I gotta admit, I said this in the last video, I did not expect the conservative justices to go against stare decisis, but man, did they defend that point very well. They defended that point so well, and this dissent doesn't really give a reason for following it. Just like, no, you have to follow this, like, it's this big hard and fast rule. Well, what about Plessy? I mentioned that earlier. Would you have said that about Plessy? Well, stare decisis, we got to keep Plessy going. Here's another telling phrase, page 25, page 172 of the PDF. They refer to Justice Thomas's concurrence, which makes clear he is not with the program. Oh, there's a program! That's what this is about, programs. So Thomas can't be a thinking individual with his own opinions. Justices can't think for themselves. No. And they don't even sound like they're writing a legal dissent. Check this out, page 27. Assume the majority is sincere in saying for whatever reason, they gave reasons, that it will go so far and no further, Scout's honor. Really? It's a 60-page dissent, not counting the appendix. I read through it wanting to find the problems with Alito's analysis, because remember, I'm pro-choice. I wanted to find all the problems with this. And it just wasn't there. It's full of invective, fear-mongering, and really backhanded ad hominem attacks against the other justices. I mean, geez, hang on, I'm losing my place here, but I don't think I'm, anyway. Yeah, it's just, Alito didn't make good arguments based on the principles of liberty. But he did make good arguments based on the principles of the law. And if you want to properly dissent, you have to make your dissent based on the law. They didn't do that. They just didn't. They wrote a Salon.com article. That's what they did. Publish this on Slate, publish this on WAPO. But as a legal dissent, it's just embarrassing. I mean, this last part, page 60, 207 of the PDF. With sorrow for this court, but more for the many millions of American women who today lost a fundamental constitutional protection, we dissent. Gee, do you want a violin playing this while you read it out? I'm sorry. I am on their side. I am, but they are embarrassments to the court. They are. This is not how you write a legal dissent. So, well, anyway, that's the ruling. As disappointing as much of it is, that's what it is now. So let's just go from here, start over, and figure out how we're going to balance these interests, how we're going to manage it, and maybe even have a real discussion about it like we haven't been able to have for 50 years. We can hope, but I've been talking for another half hour here and I feel my voice starting to go, so I'm going to leave it here. I really hope you found this valuable. If you did, remember, this was like 5 days of pretty solid work for me, so please go to donate.bogosity.tv to help compensate for that, because there's no way I'm making that back with ads. So please give what you can, PayPal or crypto. And you can also become a subscriber at Patreon or Subscribestar, get these videos early and ad-free, and various other benefits. Also, of course, comments for the Comment God, shares for the Share Throne. Please hit like, subscribe, and the bell. All of that will get this video lifted up in the algorithm so more people can see it. If you want a proper coverage from a non-lawyer type of this decision, from someone who is a pro-choicer. I am biased on this, but from someone who nonetheless wanted to go through and do a good, objective coverage of it and not the hysterics that you're seeing. So do all of that to let people know more about this. So thank you so much for watching. Thanks to everyone who's supporting. Until next time, stay strong and be free.